whatever the case may be. But apart from the kind of spokesperson, you are an active citizen and you've been involved in making sure that whatever goes to the courts remains public knowledge and understanding. And so how has that been over the last couple of days with the petition that you took to court?
What happened was the government declared that they will sell 20% of their shares in Safaricom PLC. And in January, as a petitioner, I went to court to question how the government decided to do this, the propriety, the price, and the how. And when we were in the court on the 23rd of March, Lawrence Mugambi gave us an order of status quo stopping the sale of Safaricom until this case was being heard. But Parliament went ahead outside the provisions of the status quo order, discussed and approved the sale of Safaricom. We then were unhappy with this and went again back to the High Court, and the Honourable Chief Justice constituted a bench of 3, who then had us and gave conservatory orders, stopping everything. And in fact, the effect of their conservatory orders was to take effect from the 23rd of March, meaning they reversed the approval of Parliament, which had been given on the 31st of March, and therefore the status quo was excellent. But the government then sought to appeal the orders of conservatory orders at the Court of Appeal. And when they went there, they went irregularly because, first of all, we were to be heard on the 29th of this month past, and we were to be given a proper order as to the status of the substantial hearing. But the Court of Appeal lifted the conservatory orders, giving the government a window to be able to sell Safaricom before the determination of the matter in chief at the High Court. So our concern was, how can the Court of Appeal intervene in a matter before the High Court, a bench of 3 judges who have had and are about to give a ruling on the 17th of August as to the future of Safaricom-Vodacom deal, yet the Court of Appeal lifts just the conservatory orders in a period very suspiciously to be able to allow the government to go ahead and sell. So as a consequence, the government sold it in the middle of night, and Kenya lost an important strategic asset, which was earning the government between 16 to 17 billion annually in terms of revenue for partly 240 billion. So in our contention...
But just part of it.
Yes.
It's the government stake. We're not talking about all the shares. It is a part of the government stake.
Yes, but the controlling share of the government stake. You see, one of the reasons we raise concerns about these international deals which are made by government is because of corruption. If you look at Goldenberg, it was a deal that dealt with external forces. If you look at Aglo-Leasing, it was a deal that was actually externalized so corruption could take place. If you look at JKIA with Andani, the same issue is government comes up with these mechanisms to evade the Auditor General, Controller and Auditor General, so that the money which is being paid is paid to foreign parties, and then those foreigners pay commissions on the side. And a lot of the corruption is actually externalized and hidden outside the reach of the eyes of the controller of budget, the Auditor General, and Parliament. So I am just saying that Safaricom was undersold. It should have been at between 59 to 80 shillings a share, according to our expert valuation. And also, it should have been held in the custody of Kenyan people. For example, you secure certain board seats. Who is going to be the chief executive officer? Who is going to sit on the board in order to safeguard the country's strategic interests? It's like the way the Europeans have got Airbus to contrast with Boeing. You have strategic interests that the European Union needed in terms of aircraft. So Kenya had a strategic asset in Safaricom, which we're now giving up to the hands of Vodacom and so forth. But that being said, we are back in the court on the 17th of August this month, and we are actually, it's in August, so it's actually next month. And they are going to rule on the substantial matter. The Court of Appeal did say in their ruling that the court can still decide whether or not this was legal or constitutional.
By then would have been a bit too late, isn't it?
Well, they argue, yes, it would be late, but they say that those shares can revert and compensation can come. But, you know, obviously this is a situation of trying to justify what they did. But where we are saying as the opposition is we've got the powers in the future of caveat emptor, where a new government can be able to actually penalize the people who bought this thing in an unconstitutional way and be able to ensure that it reverts to the Kenyan people. There are those things that governments can do to reverse injustices. You remember with KICC, the government of Mwai Kibaki was able to reverse it and return it to the Kenyan people. The intention of the new government coming up next year will be to reverse this illegal Safaricom transaction and return it to the Kenyan people.